Ladies and gentlemen, members of the judiciary, dear colleagues, I am Gary Bell. I will be the chair of this session today. I'm very happy to welcome you to this very happy event. There will be formal introductions in a minute, and I will also later introduce Professor Brekoulakis to you. But let me briefly do myself a little of a welcome to Michael and Laura Hwang, and thank them for their generous gift. I met Michael not a long time ago. I first joined the faculty 29 years ago, and not long after that, if you remember, Michael, you took a sabbatical from your successful practice and came to the law faculty for a few months, if I remember well. And I thought this was very interesting. Someone who is really interested in academia, a practitioner who comes, spend time in the law faculty, and your gift with your wife today is another sign of your attachment to this law faculty, and for this I thank you. For a better, more complete introduction, let me introduce you to my dean, Andrew Semester, who will speak after me. Thank you.
Dr. Michael Hwang, Mrs. Laura Hwang, distinguished guests, ladies and gentlemen, good evening. Today we celebrate the inaugural lecture by our first ever Michael and Laura Hwang Professor of International Arbitration. Many people don't realize this, but even though NUS benefits from very strong government funding, we teach our undergraduates at a loss. To enable us to do more, to enhance our programs and offerings, we need additional support. And today's event is a fine example of the impact of such support. Support that helps NUS Law to recruit and retain the finest academics from around the globe and to bring their research and teaching into Singapore. Now, in recent years, NUS Law has been privileged to have professorships associated with some of Singapore's founding generation of legal figures. We have, for example, the Kwa Geok Chu Distinguished Visitors Program and the Coomaraswamy Professorship in the Law of Evidence. Indeed, just a week ago, Professor Adrian Stone from Melbourne came here to give a lecture as the Chan Sek Keong visiting professor. Today, we honour a donor who is himself one of Singapore's finest legal practitioners. A former partner at Allen & Gledhill, Dr. Hwang was one of the first 12 senior counsels to be appointed in 1997. He served as a Judicial Commissioner of the Supreme Court of Singapore in the early 1990s and as Chief Justice of the Dubai International Financial Centre Courts between 2010 and 2018. This professorship celebrates Dr. Hwang's many contributions in the field of international arbitration. And to be frank, there are too many to name. He has conducted numerous international arbitrations as counsel or tribunal under the auspices of, amongst others, the Singapore and the Hong Kong International Arbitration Centres, the London Court of International Arbitration, the Permanent Court of Arbitration, and the International Centre for Settlement of Investment Disputes. He has also served on the governing bodies of more than 10 national and international arbitration institutions. But, as Gary has already indicated, Michael is also one of us. He taught part-time at NUS Law for many years. He has also published 2 essay collections on international arbitration and dispute resolution, as well as conducting lectures and training programs for students and practitioners around the world. He even contributed as a member of our Curriculum Review Committee and of our Consultative Committee in the 1980s. Now, with such vast experience in the field of international arbitration and such a long-standing association with NUS Law, I can think of no better person to endow this chair that has brought us all together today. And I am particularly grateful that his wife, Laura, felt the same when she first proposed the idea to him. Thank you, Laura. Now, if this were a professorship of banking law, I suspect that I would actually be saying a lot more about Laura than about Michael. In 1984, Laura Hwang became the first Singaporean and the first woman to head an international merchant bank in this country. She literally changed the game for women in our finance industry. Laura has continued to lead in many areas of public life, including acting as president of the Singapore Council of Women's Organisations from 2010 to 2014, and she remains chair of the Singapore Ballet Board of Directors. Laura has lived a life we all aspire to, a life of making a difference. And in that vein, I would like first to express our deep appreciation to both Michael and Laura for making a difference. We are grateful for your generosity, your vision, and your desire to invest in the continued growth and development of Singapore's legal community. Thank you both. Unsurprisingly, our very first holder of the professorship is with us tonight. The chair of this evening's discussion, Professor Bell, will introduce our speaker shortly. But let me take a brief opportunity to say what a pleasure it is to have Professor Stavros Brekoulakis here this evening to speak on law and the expansion of politics, the case of international arbitration. Now, the pleasure is in no little way a personal one. Stavros came to us from Queen Mary University, and he was my first professorial hire as the new dean. And hiring at this level is not just about reviewing CVs. It is a long process of building trust and of finding the kind of colleague who will make NUS law a better place. A better place, I may say, as a whole, and not just in arbitration. I believe that in Professor Brekoulakis, we have found such a colleague. And I have found somebody whom I am proud to call a friend. Yet the pleasure is also professional. As we went through the recruitment process, I realized that the field has changed. The new generation of arbitrators continues to publish. Their writing is important and valuable, but it is also increasingly practice-oriented. Nowadays, that next generation tends to be more practitioners than out-and-out academics. Against that backdrop, Stavros stood out like a beacon. He is both an outstanding practitioner and an outstanding academic. In the English language, there is no other figure of his generation who publishes regularly in the elite general law journals. Stavros has a vision for arbitration as an integrated discipline of research, teaching, and practice. And in my view, that's exactly what NUS law is all about. That's what we do. We do research-led teaching that treats the law as a living problem. And we're very lucky to have Stavros joining us in that project. Stavros will speak to us this evening about the growing tension between international arbitration and international law's traditional concept of state sovereignty. What were traditionally narrow concerns about transparency in arbitration have more recently broadened. Now they include worries about substance, especially the ability of overseas tribunals to review decisions that were formerly matters of a state's prerogative. The stakes are high. Professor Brekoulakis has a profound understanding of the issues involved, and I can think of no better person to elucidate them for us. So, Stavros, no pressure, my friend. thank you for joining us in Singapore, and I'm very much looking forward to your lecture. Now, I don't normally speak this long, but there were too many good things to say. You'll be pleased to know that I'm done. In closing, though, I would like once again to thank Michael and Laura for endowing this professorship, and it is my privilege to invite both of them on stage to say a few words. Dr. and Mrs. Hwang, please.
So I've got backup. Good evening, everyone. We thought that since all of you here tonight know the first person named in this chair, it might be interesting for you to hear a few words from the second named person. Perhaps a little history. All this started at a family dinner when somehow the subject of family philanthropy came up. And we quite quickly decided that it should be something to reflect Michael's enormous achievements in the fields of law and arbitration, which we are so very proud of and have been supportive of, and at sometimes a bit ticked off at. You know what I mean. So we all agreed that this would reflect his achievements and that it should also help others attain excellence in these fields. We are by no means billionaires, but we have worked hard, and we are happy to be able to fund an endeavor that will help others attain excellence in these fields. And it is also our hope that this may encourage other families to think of similar educational endowments to their alma maters. As an alumna of MUS, at that time, University of Singapore, we decided on the endowment of this professorship at NUS, also given Michael's very long association with NUS, although we did not meet here. And we have every confidence that Professor Brekoulakis will establish the enrichment at NUS of excellence in this field, which in today's very, very tumultuous world has made his subject ever more important. We do not want to see the world at war. We have lovely children such as Anna and Yanis, and our grandchildren to think of in the coming generations. And I think that people have to talk, and international arbitration provides the venue for those meaningful talks and negotiations to take place. So a lot rests on your shoulders, Stavros. Thank you very much.
Dean Semester, Professor Brekoulakis, Professor Bell, distinguished guests and friends. As you have heard, my wife Laura was the one who suggested that I should give an endowment, or we should give an endowment as a permanent memorial of my commitment to the development of international arbitration in Singapore. And that is why our joint names appear on the title of this chair. It's also an advance gift from me to my wife in celebration of our 50th wedding anniversary, which falls in this year. But why did I choose? That doesn't stop her from requesting additional gifts. But why did I choose to create this endowment in NUS? I had two other choices: Oxford, where I first learned my law, and Sydney, where I first taught law. And I still have warm feelings about these two universities. But the reality is that I spent the longest time teaching law at this university. When I came back to Singapore in 1968, after 9.5 years away from home, my immediate task was to get called to the bar, so I immediately joined Allen and Gledhill as a pupil, and later as a lawyer. However, I still retained thoughts of remaining as a teacher of law, just in case I didn't take to legal practice. And I then went to see Dean Teo Soo Mien and offered my services as a part-time tutor or lecturer. She offered me family law. Now, Oxford, being what it was, didn't teach practical subjects like that. But nevertheless, that was the only subject on offer, so I took it. My performance in that, teaching that subject, led the law faculty, seems to have been impressed the law faculty sufficiently to give me different subjects to teach on a part-time basis, from contract law to labor law, civil procedure, and even giving a full lecture course on company law, another thing that Oxford didn't used to teach. So I became the faculty's spare part for about 10 years, when the whole university moved from Bukit Timah to Kent Ridge. And I decided to take a break from teaching. But even when I'd stopped teaching, I was still involved with the faculty as an external examiner on family law, helped out with reviewing PhD theses on banking law and land law, which I acquired knowledge of through my practice, as well as becoming involved with the faculty's ancillary activities, like serving on the editorial board of the Malaya Law Review. Remember that? However, I was lured back to the faculty in 1986 when I was appointed as a member of the faculty's consultative committee from 1986 to 1991 under the chairmanship of the late Justice Lai Kiew Chai. Justice Lai and I, through the curriculum review committee, managed to persuade the faculty to adopt new subjects relevant to international commercial law, like conflicts of law and corporate finance. In 1999, I was very honored when the faculty offered me a visiting professorship at the faculty in the second half of 1999, which Professor Bell has told you about. And I was teaching then in that semester international arbitration and civil procedure. After that rewarding period as a visiting professor, I was later recruited by the building faculty of NUS to be an adjunct professor to help that faculty to teach a course designed by King's College London in construction law. And I did that on a part-time basis for about 8 years, from 2005 to 2013, at the end of which I received this necktie that I'm wearing tonight. So I've had a lot of experience working for and working with this university, and therefore when Laura proposed this endowment, there was no doubt in my mind which university would be the recipient. While I had no part in the decision to appoint Stavros as the first holder of this chair, I have to say that I cannot think of a more appropriate choice than him for all the reasons that Gary Bell has given us, and I look forward to a new golden era of academic development of international arbitration jurisprudence in Singapore under his leadership. And I would be very gratified if history would record that Laura and I played a small part in this development. Thank you very much.
Thank you, Michael. It now is my great pleasure to introduce to you my colleague, Professor Stavros Brekoulakis. It is my job, in a sense, to show to those of you who don't already know him that we made a good choice. Stavros, as you know by now, is the Michael and Laura Hwang Chair of International Arbitration. Stavros has practiced as an arbitrator, also practiced as an arbiter from 3 Verulam buildings in Gray's Inn. As an academic, he's a leading authority in the field of international arbitration. He has been invited, for example, to give the summer course on private international law at the Hague Academy of International Law in 2026. And the subject of this course will be, and also subject of his monograph, will be on the intellectual history of international arbitration. For those who don't know, the Hague Academy of International Law, this is quite prestigious to be invited to that academy. Stavros currently has leading roles in thought leadership projects. For example, 2 of them. He is a co-chair of the Institute of Transnational Arbitration Task Force on the Rule of Law in International Arbitration, as well as a second project, which is he's a primary investigator in a major interdisciplinary and empirical project on impartiality in arbitration decision-making. Stavros has also worked on third party in international arbitration, including an Oxford University Press monograph. And he's a leading authority on the topic and has been cited by international arbitral tribunal as well as national courts in many jurisdictions. Stavros' more recent work as a co-chair of the International Council of Commercial Arbitration Task Force on third-party funding and in the ensuing report has become a major reference on this topic. And it has informed many legislators worldwide in how to approach this issue and amongst the inspiration for best practices in the field. Stavros is a leading speaker, public speaker, has participated in many debates in the field of international arbitration. In 2020, he received the Global Arbitration Review Award for Best Public Lecture. It was the Rumbock Arbitration Lecture, the policy favoring arbitration under English law. He's also shortlisted for the same prize for a lecture he gave here at Maxwell Chamber last April on the impartiality and construction of trust in international arbitration. As a practicing arbitrator, he has sat on more than 100 arbitration cases in all major jurisdictions, as well as under different arbitration rules. He is recognized for his work in arbitration and by his peers and listed as a global elite thought leader and in the who's who of legal ranking of arbitration. Finally, he serves on many boards and commissions. For example, he's one of the vice presidents of the ICC International Court of Arbitration, and he's a member of the governing board of the International Council for Commercial Arbitration. He serves as general editor of the Journal of International Dispute Settlement and co-editor of Kluwer's International Arbitration Law Library series. Stavros, we're very lucky to have you. I'm very happy that you have accepted our invitation, and I invite now to give your lecture tonight. Thank you.
Dr. Hwang, Mrs. Hwang, distinguished guests, ladies and gentlemen, two little kids. I'm standing here before you this evening with a mix of profound honor and trepidation. Honor because this lecture aims to celebrate my appointment to an NUS chair that bears the name of Michael and Laura Hwang. I've known Michael for many years. You heard his distinguished career, and he has been a leading light of international arbitration and an inspiration, personally, for me as well. What I didn't know was Laura, a leading banker in her own right with such remarkable energy and creativity. It has been a real pleasure to get to know both Michael better and meet Laura, and I want to thank them in public for their generous contribution for the establishment of this chair. I would also like to thank NUS, and in particular Dean Andrew, for their trust in me. Over the year, I've developed with Andrew not just a wonderful working relationship, but as he also mentioned, a friendship. This is quite a rare thing to do with your boss in a year. I would equally like to thank my colleagues in the faculty and in the arbitration field here in Singapore. When I first arrived in Singapore a year ago, I heard everyone speaking about the ecosystem of international arbitration. I didn't really understand what that meant. A year later, I do know. It is this genuine warmth to include everyone, this sense of community and common purpose. You have all made me feel that I am here living for many years. Thank you for that. And I can only hope to repay your trust and serve this chair, NUS, and the arbitration community in Singapore with all my energy, ideas, dedication in the years to come, starting from this inaugural lecture tonight. And this brings me to the trepidation part. This inaugural lecture is an opportunity for me to demonstrate my commitment to intellectual leadership and set out my broader views and vision and ideas for the field of international arbitration. And this is not an easy task to do in the next 45, 50 minutes. I hope you will bear with me as I now turn to this task. Should a private international tribunal of 3 individuals decide whether a decision of a foreign government on matters concerning its economy, public health, and environment unlawful or unlawful under international law? Should important decisions of policy and governance be subject to a rules-based system of international justice? As I will come to explain shortly, the answer that most of us would have given to these questions 40 years ago might be different from the answers that we might give today. While previously most people would answer this question with a resounding yes, today a critical mass is likely to say that governmental decisions on public policy are essentially political questions and should be left to the discretion of the governments, not international law and tribunals. This is the first thing that I will argue today, that the space for international law is currently narrowing down. The second thing that I will address is the question of what's changed. What's changed that we've now considered that international law should occupy a narrow space? As I will argue, what's changed was the political context surrounding international law. After a constant growth in the first 60 years after the World War II, international law reached the point of saturation, of excess. And at this point, the broader political context started to shift from liberalism to national sovereignty. This shift has had profound implications for the scope and role of international law, and I will spend some time to speak about those implications. I pause here to say that the proposition that international law may change because the political context changes is a counterintuitive one, perhaps even controversial, especially when you speak to an audience full of lawyers. Since Kelsen, international lawyers are hardwired to think that the law is firmly separated from religion and politics, that the law is a self-contained system that reflects lasting notions of fairness and justice that transcend the ephemeral whims of politics. But that, of course, is wrong. The relationship between the law and politics is one of continuous struggle. Take any conceptual analogy you like. You may illustrate the point as thinking of it, of the relationship as a zero-sum game, a roller coaster, a pendulum. The outcome will be the same. Politics tend to occupy the space that law leaves behind, and vice versa. And I will explain to you today how the struggle has played out in the field of international arbitration in the last decades. The third thing I will do is to provide a normative assessment of this shift from international law to politics. As I will argue here, we are now at a sorry state of affairs, which is unsatisfactory by any account. And the final thing I will do is to propose a possible way forward and out of this sorry state of affairs. So this is an overview of the four things I propose to do today. While in the first two, I will mainly describe, explain. In the last two, I'll set out my own contribution and ideas to the current debates. In other words, I try to earn the promised glass of champagne at the end of this lecture, the principal reason that you're all here tonight. But before I start to explain the rise and decline of international law, I need to briefly define the main concepts that I will use to set out my thesis. First comes international law. I'm using international law in its liberal expression, that is a system of rules-based global governance that seeks to limit sovereignty and to keep states' power in check. And to do that, international law provides that the conduct of states is subject to review by an independent system of justice, which can take the form of international courts, international tribunals, in our case, in our field, in the form of international investment tribunals. Now, international investment tribunals are ad hoc tribunals, ad hoc panels comprised of 3 arbitrators who have the power to adjudicate disputes between a state and a foreign investor. Right opposite to this idea of international law is the idea of politics. The idea of politics I will use tonight is drawn from Smith's foundational work on the concept of the political. In summary, Schmidt argued that the political concerns of the state are above the rule of law. For Schmidt, the ultimate source of power in any constitutional order is the power of the executive, not the judiciary. It is the sovereign executive that must take the ability to decide, have the ability to decide how to protect the essential interests of the people, especially in times of crisis, what Schmidt called the state's power to decide the exception. And the decisions that the executive will take in those circumstances should not be subject to any form of judicial review. But some of the questions that Smiths, I recognize, have posed are troublesome for anyone who is committed to defend the rule of law. Now, I want to recognize that Smith's association with the Nazi regime was heinous by any account. But it's those questions, these uncomfortable questions that he has given rise to, that I think if we're serious about the rule of law, if we're serious about international law, we need to give an answer, we need to grapple with. Having set up my two main conceptual blocks, I now turn to the first point I want to argue today. That's the rise and decline of international law and correspondingly the decline and rise of politics. After the horrors of World War II, international lawyers considered that more international law was the answer to make our world a better place. Laura made the case very clearly about the role of arbitration in international law. These international lawyers embarked in a relentless project of setting up more international legal institutions, drafting more international treaties. The lofty aim here was that more international law would foster global peace, economic cooperation, human rights, prosperity. The number of international treaties, international institutions that were produced in the first 40 years after World War II was more than the number of international treaties and institutions that had been produced since the inception of international law by Grotius. In the period, we have the treaties ranging from the Geneva Conventions on war crimes to the GATT Agreement on tariffs and trade, the Bretton Woods agreements on international economic law, and of course, a number of conventions on human rights and environmental law. In the field of international arbitration and investment law and property rights, which is the topic that I'm concerned with today, the expansion of international law took the form of a large network of international trade and investment treaties. These international trade and investment treaties had two immediate and two broader implications for states. The first immediate implication was that by entering into those treaties, states were agreeing to protect property rights of foreign individuals and corporations. Specifically, states were agreeing to do three things. First, that they could not expropriate private property without compensation and due process. Second, that they had to treat private property and investment in a fair and equitable manner. Hold on to this idea, I will come back later. And third, that they could not discriminate against foreign owners and property rights. With the passage of time, more states were agreeing into more international treaties and agreeing to protect more property rights of almost every national in the world. Treaty making became a frantic project. From the first modern investment treaty in the late 50s between Germany and Pakistan, and until now, we have more than 3,000 investment treaties that have been signed. The second immediate implication was that not only did these treaties provide that states had to protect foreign property rights, they also provided for the first time that individuals or corporations could bring a direct claim against a state every time a state breached those obligations. Never before had individuals direct and actionable rights against states in such a far-reaching manner. This is important because it gave rise to the idea of international investment tribunals. If individuals and corporations had rights against states, they also had to be able to adjudicate these rights somewhere. And this somewhere could not be the courts of the state itself, because evidently courts were not trusted to fairly adjudicate a claim against their own state. We had to create a system of international justice that would sit outside the reach of states. And in the minds of the liberal international lawyers at the last century, another international treaty was the answer to whatever the world's problem was. And presto, they drafted the Washington Convention in 1965 that created the system of international independent justice, which took the form of ad hoc international tribunals that had the power to review states' actions and hold them accountable for violation of property rights. This all sounds commonplace today, but they were most certainly not 60 years ago. Back then, states had a very thin obligation to protect property rights in accordance with minimum standards of protection and the customary international law. Importantly, even when states were breaching their bare minimum obligations, individuals and corporations had no recourse against the states. Rather, that they were at the mercy of their home states. If property rights of a foreign investor were violated, the investor had to rely on their home country to intervene on their behalf and engage in diplomatic negotiations with or use its force against the state that violated property rights, what we call gunboat diplomacy. Thus, back then, international law was thin, patchy, and state-centered. It was the liberal project of treaty-making and institutional building of the last century that effected this dramatic shift in international law from state-centered power to individual rights and state accountability. This brings me to the two profound implications that the liberal project of international law had for states and sovereignty. First, it turned national to international. Before World War II, states were mainly constrained by their domestic constitutions only, and their conduct was reviewed by domestic courts only, either by constitutional or by way of administrative review. But as the Weimar experience in Germany in the late 30s showed, the idea that a state could be constrained by its own national law and courts proved fanciful. A sovereign could always trigger the emergency clause that we find in all constitutions to suspend the law and neutralize national courts when they wanted to. International lawyers, therefore, had learned their lesson. National constraints were hopeless. We had to set up a form of international constitution and a form of international judicial review so that states could no longer practice their escape art and remove their constitutional straitjacket at will. Turning national to international was key to limit state power and keep the executive at check. Second, the liberal project turned politics to law. From that time on, questions of policy were framed as legal questions that should be answered by reference not to political expedience, but legal rules and legal tests. Thus, and I draw here on real high-profile cases, many of them would be familiar to all of you. Whether Uruguay, for example, could pass anti-tobacco legislation that included placing graphic health warnings onto cigarette packaging was no longer a question of whether the state's regulation to implement anti-tobacco policy was expedient. It became a question of whether the state's regulation had violated trademarks of the investor and the tobacco companies. Whether Ecuador could decide to terminate the exploration of fossil fuels in Amazon was no longer a question of whether the state's decision to protect its environment and control its natural resources was an expedient policy. It became a question of whether the state's decision met the legal test of the fair and equitable standard under international treaties. And whether Argentina could take emergency economic measures, such as to abandon the peso's fixed exchange rate with US dollar, was no longer a question of whether these measures, seeking to address the state's unprecedented financial crisis, were expedient. It became a question of whether the state's measures breached the legal test for expropriation and a fair and equitable standard. And finally, whether Germany could decide to close down a nuclear plant was no longer a question of whether the state's decision to abolish its policy for nuclear energy was expedient or not. It became a question of whether closing down the nuclear plant met the legal test of rationality under the fair and equitable treatment in international treaty. And the answer to these legal questions were now importantly given by international tribunals of three individuals. The state had no saying in that. In answering these questions, international tribunals sometimes found that the state's decisions were legal and in accordance with international law, and sometimes they found that they were not. But this is beside the point. What matters was that by turning national to international and politics to law, the system of national sovereignty that was at play since the Westphalia Truce of 1648 had now been displaced in favor of a system of international legal order. At the time, there was a sense of moral gratification among liberal international lawyers, and that the global constitution and independent justice that they have put together would govern international affairs in a principled and dignified, if not always peaceful manner. At last, the rule of law was accomplished, it was thought. In the next 50 years, law would thrive over politics. There were the years of law's empire, to steal from Dworkin. Smith's concept of the political was defeated both on the ground and the field of ideas. But there was a problem there. There was a problem with the triumph of international law over politics. Or rather, there were three problems. The first was a problem of scale, because a system of global adjudication was now available and in place. Crafty international lawyers soon realized that they could frame almost any political questions in legal terms and set them for adjudication to international tribunals. While initially the questions that were referred to international tribunals were relatively straightforward questions of expropriation, increasingly, more international law was laid at the feet of international arbitrators. There came a point where arbitrators were routinely asked to decide fundamental questions of public policy, including how states should respond to pandemics or to financial and climate change crises. In some cases, we have arbitrators being asked to decide whether the measures that some European states took to satisfy the condition for their accession to the European Union were lawful or not. These are matters of profound economic and geopolitical importance. And the more matters of profound economic, of these public policy issues were referred to arbitrators, the more matters arbitrators would take. By way of example of that scale that I'm talking about, in the 50s, there were only about 5 registered cases against states. In the 90s, the number of cases rose to 50. By 2010, the number had risen to approximately 400. Today, we have more than 1,300 known cases challenging a wide range of executive decisions, legislative decisions, judicial decisions taken by the states and the judiciary. There were 50 claims filed only against Argentina to challenge the measures Argentina took in response to the financial crisis in the 90s. More recently, we had more than 40 claims against Spain for decisions it took in respect of renewable energy policies. This audience will be pleased to know that there's no reported investment claim against Singapore yet. Many have accused arbitrators of accepting these cases mainly because of a handsome financial reward that comes with it. I cannot deny that monetary considerations may have been part of it, but I think it's too simplistic an answer. I don't think that international arbitrators had any play in that. And anyway, they were not mainly motivated or indeed exclusively by profit. The majority of arbitrators, we are international lawyers who are genuinely excited by complex questions of international law, and we want to be part of the settlement of big matters, dealing with the hard questions. In many respects, this is a healthy and lofty ambition. The second problem was judicial activism on the part of some arbitrators. Not only more political questions were referred to arbitrators, dressed up as questions of international law, but also, and importantly, arbitrators started to push the founders of international investment law to dramatically develop the standards of protection of these private rights and correspondingly to increase the scope of liability of states. The national arbitrators were allowed to do that because the system of investment adjudication was set up with wide discretion in the form of broadly formulated legal standards, such as the standard of fair and equitable treatment that I referred to, but none of the typical balances that keep decision-making discretion in check. There was no doctrine of judicial precedent, no appellate body to guide the jurisprudence of international tribunals. And while in many cases states were winning, in many other cases states were losing for having taken decisions which states thought were ordinary executive decisions that were traditionally within the political discretion. States were genuinely perplexed that the traditional bare protection of property rights had evolved through a series of arbitration decisions to occupy increasingly more political space. The third problem was a problem of attitude. I mentioned a few moments above that I do not consider that arbitrators accepted more cases and pushed the limits of international law merely for monetary reasons. Greed was not our cardinal sin. Pride was. As we were dealing with more and bigger international law, international lawyers and arbitrators gradually developed a sense of intellectual vanity, that we were the global arbiters of the world's affairs. Not only we have the legal authority to deal with any question, no matter how big it is, but we have the indisputable moral prerogative to decide when a state is right or wrong. Most international arbitrators, we were born at the time when the shift from sovereignty to global governance had either started or was well underway. In that sense, most of us are liberal lawyers by outlook, not in the US sense of the world, but in the sense of classic liberalism, which understands international law as ameliorative, as a means that can correct the world's injustices. Many international arbitrators genuinely thought that it is our mandate to use international law to do so. Again, whatever the reasons behind it, this attitude of entitlement was perceived by some as hubris. As these problems together, scale of international law, judicial activism, and attitude, started to give rise to questions from the public, the media, and of course the states. How can three people decide important questions of public policy? How can they award damages of hundreds of millions against the state? Who are these people? Where do they draw their power from? Who elected them to be the arbiters of the world? Initially, the answer of international lawyers to these questions was that international tribunals were formed in accordance with rules of international treaties which states had signed in the first place. This may well be, but is not a reassuring answer to the minds of the public and politicians. The fundamental issue here was not the process of appointment of arbitrators, although it was admittedly an important issue too. The fundamental question from the public was that we elected a government to deal with these questions, not through foreign legal technocrats. And questions bring about pushbacks and reactions. In this case, we had two kinds of reactions. The first is a project of reform to reform international investment law and arbitration and their excesses. Some reforms aim at addressing problems with regard to the way that arbitrators are appointed and the way they decide. The idea here is to replace arbitrators with tenured judges to eliminate arbitral activism. Other reforms aim at amending the text of international treaties to explicitly provide for more space for states to regulate their affairs. However, all of these proposed reforms essentially aim to preserve the status quo. They are all underpinned by this familiar idea that states' decisions of policy should, as a matter of principle, be subject to international law and a system of independent justice. We just need to improve the system, the thinking goes. I personally consider that some of these ideas, although not all, are quite reasonable. But I'm not the arbiter of this matter. Excuse my pun. Important point here is that we've now come to a point that none of the proposed reforms can placate the criticism. They are considered to be too little, too late. And a critical mass of states does not just want to correct the excesses of the system, they seek to change the paradigm, to reinstate the primacy of the political, to grant national sovereignty the power to decide the question, the Smithian question of exception again. It is against this background that in the last 10 years, law has started to retreat. Politics are winning again, both on the ground and in the field of ideas. On the ground, in a series of decisions, the European Court of Justice, the ECJ, has declared that international investment arbitration is a system of independent justice that sits outside the EU, and therefore it is not acceptable. The decisions of the ECJ in Comstroy, Acme, and PL Holdings are well-known decisions to many of you, and I do not intend to discuss them in any detail. I would say only this, though, that the fundamental point that the ECJ makes in all these decisions is that the question of how an EU state can deal with questions of policy is a question that falls outside the purview of international law, investment law, and tribunals. In compliance with these ECJ's decisions, a number of European state courts are now striking down arbitral awards on the grounds that the questions of European law that were referred to these tribunals in the first place were matters of public policy, and as such, these questions were, and I quote, non-arbitrable. Pay attention to the court's jargon there. They call these matters non-arbitrable. In other words, courts do not simply strike down arbitral awards because the tribunal is considered to have made an error or violated due process. Courts say that these matters are now matters of public policy and fall outside altogether of the scope of judicial review of international arbitration. A year ago, the EU member states collectively decided to withdraw from an important multilateral international treaty, which is well known as the Energy Charter Treaty, which I will call ECT. The main objection of the EU states was that this international treaty, the same treaty that states had originally negotiated and signed back in the 90s, was now curtailing the EU's political discretion to set its own environmental policies. And what was the solution of EU states to the constraints imposed by this international treaty? To withdraw from the treaty with immediate effect and to reassert their political authority to take policy decisions on environment unconstrained by international treaties and tribunals. A number of bona fide international lawyers point out to the obvious. A state cannot simply withdraw from a treaty with immediate effect. The ECT, as many international treaties do, have a clause also known as the survival or sunset clause. The survival clause says that if a state decides to withdraw from the treaty will still bind the state for the next 20 years. The logic here is that you cannot just pull the plug suddenly. The logic makes sense. States must give sufficient notice to investors and everyone that have acquired rights and have made investments to gradually shift to the new system of protection. And what was the solution of the EU Commission and the EU states to this fundamental problem of international law? To declare survival clauses an international law way. In June last year, the EU and 26 out of the 27 EU states signed a formal declaration to declare that the treaty survival clauses, these sunset clauses that provided that the treaty would still be applicable for 20 years, have no effect on them. And thus, with immediate effect, no further claims can be brought against EU states under the treaty. The EU states declared that not only that future claims against states are now impossible, or pending arbitrations against states are now retroactively terminated. If you ask any third law year student, they will immediately tell you that this is plainly against the rules of international law and the Vienna Convention of the Law of the Treaties. The answer would, of course, be correct, but entirely beside the point. The point being that matters are now firmly back into the hands of sovereignty. Now, the most alert of you must have noticed that I said a moment ago that the declaration to withdraw from the ECT with immediate effect was taken by 26 out of the 27 members of the EU. The odd one out was Hungary, which disagreed with the majority's decision on the ground, which by now is banal, that such a declaration would infringe international law. What was the EU Commission's reaction to Hungary's opposition? Initiating proceedings against Hungary and threatening Hungary with a fine for undermining the EU law and EU position. EU states have not just reasserted political power over international law in respect of pending or future arbitrations. They've also refused now to abide by awards that have been issued years ago. In the last 10 years, Spain has lost more than 20 arbitrations for violation of investment treaty provisions. The outstanding amount of damages that Spain has to pay from these awards amounts to over $1.5 billion. Spain staunchly refuses to pay any of these awards on the grounds of, well, you guessed it, sovereign immunity, which is basically a defense which is Smith's idea of the exception dressed up as international law. In 2005, and at the time before Romania acceded to EU, and I highlight this fact, an investor started arbitration proceedings against Romania. After several years, the tribunal ruled at the end of 2013 that Romania had breached international treaty law and awarded to the investor more than 150 million euros in damages. Romania had in the meantime acceded to the European Union, and soon after the tribunal issued the ruling, the EU Commission directed Romania not to pay up the award on the ground that payment of damages would breach EU law for state subsidies. To point out the obvious here, we have an executive body ordering a state to entirely disregard the decision of international independent justice taken on the basis of international law. But it's not just EU states here. The Global South is witnessing a number of withdrawals from international investment treaties. The new policies to agree that disagreements over investment disputes will be now decided not on the basis of a system of independent justice, but on the basis of state-to-state adjudication. I pause here to say that the expansion of politics over the law is obvious, not only in the field of international investment law and arbitration. This is a symptom of a broader direction of travel right now, with sovereign governments reasserting at will their power and retreating from a rules-based international order. Just look at the imposition of tariffs, the paralysis of the appellate body of WTO, the withdrawal from international organizations, as well as international treaties on environmental law. It feels that we are reaching the apogee of politics reassertion over international law. States are not just moving the goalposts here, they are moving the entire pitch from the Peace Palace in The Hague to 1600 Pennsylvania Avenue in Washington, D.C., and number 200 of Rue de la Loi in Brussels, where the EU Commission resides. In the field of ideas, Francis Fukuyama's famous declaration about the ultimate victory of a liberal legal order is now at best perceived as naive, or at worst, widely ridiculed. In the aftermath of the pandemic's experience and realization that sovereign decisions must be taken on a decisive basis, Schmitt's theories on sovereignty and the state of exception are quickly catching up with intellectual discourse and have significant impact on debates about constitutional theory and international law. William Shorman, with the telling title of his book, The End of Law, observes that Schmitt is now a household name in the English-speaking academic world, and his work is more popular than ever. Giorgio Agamben has developed Schmitt's idea to argue that modern democracies increasingly rely on emergency powers to take sovereign control outside legal norms, outside legal order. Taking a more radical perspective, Chantal Mouffe builds on Schmitt's idea to argue that an expanded role of the political over the liberal idea of law's neutrality, which Mouffe criticizes as completely fanciful. And finally, Robert Hauser employs Schmitt's theories to criticize liberal international law as lacking any sort of democratic legitimacy. The specter of Carl Schmitt and politics are now haunting international legal order once again. How many decades can the dish of revenge stay cold before being finally served? Now, I recognize that for our inaugural lecture, I'm offering a rather bleak account of current affairs. I sense that you all look forward to hearing the words in conclusion and to rushing to the wine bar. Stick with me for a moment. It gets better. Having explained how the politics have now encroached on the law, I will now turn normative and seek to give an account of what ought, in my view, happen from here. Let me preface what I'm going to say with this. The forthcoming observations are broad brush propositions. I admit that they account for no comprehensive theory yet, but I do believe that they are getting at something potentially, hopefully interesting and important that warrants some further exploration in the years to come. The starting point of my observations is that the state of unabashed international legal order is unsustainable. And by unsustainable, I don't just mean difficult to survive in the current political context. I also and mainly mean normatively wrong. The idea that we can depoliticize disputes on broad policy questions by simply casting them in the legal discourse about rights is entirely fanciful. Political contestation always catches up with the law. And when political contestation eventually captures the law collapses. This is exactly what has happened in the field of international investment law and arbitration. For some years, liberal lawyers thought that they had managed to insulate property rights from politics. But as I described above, politics have now caught up with the law and have effectively nullified it. So here is the proposition number one: litigation cannot substitute for political reasoning. Equally, though, a world that is guided by a Schmittian conception of the political is a dangerous world that paves the way to totalitarianism. I do not need to remind this audience what happened, what followed after Schmitt's theories in the late 30s in Germany. Even if we stripped down the inflated doctrine of the rule of law to its bare minimum, the idea that states must be accountable to a system of independent justice ought to be the lodestar for any form of political structure that is worth living in. So here's proposition number two: states' conduct must be assessed against certain standards, and if states' conduct is assessed and found wanting, states must be liable for that. In other words, we must recognize the necessity of the political and the importance of the law, and find a principled way to mediate between these two. To do that, we need to identify the space where the political and the law intersect. And the space, I will argue, is the concept of public interest. All disputes that give rise to these hard cases in the international investment law have the questions of the public state at their heart. And here's the big issue in my view: the current law of investment has no legal doctrine to properly account and protect the public interest. The closest functional equivalent in investment law is the doctrine of fair and equitable treatment, which we find in all investment treaties. But the abstract formulation of this standard, as well as the evolution of arbitral jurisprudence, make now this standard problematic. It may sound paradoxically, but lawyers cannot deal with abstract conceptions of fairness and equity. Being all positivists, we best deal with narrow legal rules and specific legal tests. It was only natural, therefore, that when lawyers were asked to apply the standard of fair and equitable treatment, we analytically dissected the standard to a set of rules and requirements. And as a result, we ended up with a deconstructed standard that simply draws the line of demarcation between law and politics too generously in favor of the former and leaves little room for political discretion. Equally, the doctrines of necessity and police powers are so restrictively formulated that do not allow states to meaningfully exercise political discretion. Just to give you an example, many tribunals rejected Argentina's defense of necessity to justify the emergency economic measures it took to address the severe financial crisis faced in the 90s. This is not a criticism for the tribunals. They applied the law. The law is just too narrow. On the other hand, retreat to the minimum standard of treatment under customary international law would not be an appropriate alternative. This standard, which is effectively the lowest common denominator of state conduct globally, is way too thin to offer meaningful protection to investors. I would therefore submit that we need to develop a new theory of the public interest. It should be a modern and coherent theory that properly accounts for and protects the public interest, and use this new theory to develop fair and appropriate standards to assess state conduct in investment arbitration. Importantly, I would submit that this theory cannot be the work of lawyers only. After a wave of interdisciplinary work that has swept international law in the last 30 years, we now know that law alone does not have the intellectual tools to construct a theory that seeks to transcend the fields of law and politics. Law cannot pull itself up by its bootstraps here. The concept of the public interest is by nature one that is interdisciplinary. To understand this concept, we need contributions from different disciplines, including law, political science, economics, sociology, the discipline of public policy, and environmental studies. While the law can address the often narrowly formulated questions of legality of governmental conduct, political science can inform us on the question of what is the collective good that elected governments should pursue. Equally, economics can assist us to understand whether certain policies aim to maximize social welfare, whereas the discipline of public policy can inform us about the evaluation of whether a measure, whether governmental action is effective and fair. Now, a proper assessment of the public interest involves a wide range of considerations that cannot be addressed only by the law. The answers that lawyers have come up with to protect public interest are simply not good enough. But this does not mean that we should replace law with politics. Rather, we should seek to collaborate with politics as well as other disciplines. In other words, we need to roll up our sleeves, work across disciplines, and develop a principled and coherent of the public policy for the purpose of assessing questions about whether the protection of international public law under investment law as well is sufficient. A new center of international arbitration here in the US might be a good place to start this theory, this inquiry. Now, once we come up with such a transdisciplinary standard for the protection of the public interest, we do also agree on a forum that should adjudicate the standard. And here, for better or worse, ad hoc international tribunals are not perceived any longer as being the appropriate form of justice to adjudicate these kind of questions. This is not because international arbitration is currently under severe criticism. I've argued elsewhere that a large part of this criticism is unfair. Arbitration largely works at the majority of investment disputes. It's just these few cases, these hard cases, that have brought about arbitration's demise. The main reason that international arbitration is not appropriate to adjudicate hard cases that involve the public interest is exactly because, as I explained, the concept of public interest transcends disciplines. We thus need broader resources. We need the expertise that comes from different disciplines to properly assess the public interest. In other words, we need a system of justice that breaks down the barriers of law. There's no reason to think that the task of administering justice and ensuring accountability should be a matter of law only. This is especially the case in disputes that involve complex assessments, broader considerations, and potentially far-reaching political, social, and economic implications. I pause here to say that a great colleague of ours and a prominent commentator has argued that we need to insert politics back in the process. I certainly agree with the premise, but I do consider that we should approach this differently. The way it has been suggested that we should insert politics back into the process is by making the process more inquisitorial to allow tribunals to call interested social groups to give evidence in the arbitration. In that way, it has been argued, arbitrators can decide with a better understanding of the political context. However, this approach effectively doubles down on the law. While it allows social groups to provide evidence in the arbitration process, a final decision will still rest with arbitrators who will have to decide the same questions on the same legal standards and the same tests. It is not the process that is the issue here. In fact, counsel and witnesses in arbitrations do give the broader stories to arbitrators about how the public interest has been affected by investors and vice versa, about how states' contact has wrecked businesses and sometimes personal lives. But arbitrators really take those stories into account, rarely take those stories into account when we decide. Not because we're a group of insensitive, impervious individuals, but because the legal tests in their current formulation and jurisprudence do not allow for this sort of wider considerations to be taken into account. In fact, lawyers and arbitrators were not trained or equipped to make assessments outside the law. Even if the process was more inquisitorial, the outcome would be the same every time that lawyers alone had to decide these questions of public policy, because we do decide them eventually on the basis of narrow legal tests. I thus submit that instead of legal panels of adjudication in the form of international arbitration, we need panels of standing committees that incorporate expertise and insights from other disciplines that have wide fact-finding powers and resources to support their decision-making task. In all cases, we should place the system of justice outside the reach of states. Complete independence from states would be important to ensure neutrality. This would not be the first time that such an interdisciplinary approach to justice existed. By way of example only, several competition authorities and tribunals, such as the European Commission Department for Enforcement of Competition Rules or the US Federal Trade Commission, the UK Competition and Markets Authority, the UK Competition Appeal Tribunal, all of them include economists in their decision-making panels. The Unified Patent Court, which hears challenges to European patents, is comprised of distinct pools of legally qualified and technically qualified judges sitting in panels of 3 or 5, in recognition that legal expertise does not suffice to determine complex questions of patent law. In all these examples, an interdisciplinary approach to the adjudication and delivery of justice will both improve accuracy of the outcome and enhance fairness and legitimacy of the process. In conclusion, if we're serious about addressing the inadequacies of the current system of justice for international investment disputes, we should be willing to let go of the legal grip. We should be able to develop a new interdisciplinary standard of assessing public interest disputes and include non-legal expertise in the decision-making process. Yannis, Anna, apologies if I bored you. Everyone else, thank you for listening.
Thank you very much, Stavros, for this fascinating lecture and very interesting lecture. We now have time for questions until we have almost 30 minutes for questions. Maybe I will take the privilege of the chair to ask you the first question. I'm very interested and very fascinated by this idea that indeed we have to be more multidisciplinary and try to change the process in that sense of having a broader view. But to which extent will that be pluralistic in views as well? The developing world have been complaining about the investment system for a long time, saying this was an imposition of the West. It's often the perception that is taken by many countries, which is explaining why so many countries have rejected, ended their investment treaties. To what extent other systems, because to many of them it was viewed as imposing Western concept of property, protection of property, socialism rejected. They were lucky if all they had was an award against them. In some cases it was a coup organized against socialist-oriented regimes in Indonesia, a war in Vietnam. But there's lots of ways in which this concept was imposed to some extent. Now, how are the voices of the developing world going to be heard in that debate?
I think, Gary, you raise a very important question, which is the question of plurality in the pool of arbitrators that currently deal with those disputes. There has been an issue here for many years. We have improved massively on that. You have now more people coming into the system, especially people from what you call, Southeast Asia, the Global South. We have some brilliant arbitrators taking appointments of that. We still have a long way to go. I'm not going to deny that. It is still a problem. It is still a problem for Africa. It is still a problem for Southeast Asia. But that's a problem that has to do with the composition of tribunals. I accept that. I'm saying that even if we had these pluralistic views, sitting in all arbitration panels, we would still have a problem. The problem would be the law itself. It's not, in my view, equipped right now to protect and account for the public interest in a way that we should have in this modern world. So not only we need more pluralistic voices coming outside from the typical pool of arbitrators, but we need also voices coming from different expertise, from different disciplines. As I said, we need to find a principled, intelligent manner to break down the barriers of the law.
But even there's a need to be pluralistic. If you're going to consult economists, if you're going to consult sociologists, you need to have views from the developing world there, not just in the arbitrators.
Oh, absolutely, and I'm not suggesting for a minute that more expertise from different disciplines should somehow account for the lack of the pluralistic voices from all the regions that you say. Absolutely, these two should coincide together. More pluralistic views from other regions, more views from other disciplines. If we are serious about developing an international system of justice that can be fair, can be perceived fair for resolving issues of the world, of the global, we need to be able to reflect this system, the expertise, all the views, and be able to reflect the values, the views of the globe.
Thank you. First question.
Thank you very much. So I found this extremely intriguing, and thank you very much for the thought-provoking lecture. It seems to me that part of your proposal, and an important part of your proposal, is that this multidisciplinary tribunal court, whatever it may be, would have wide-reaching fact-finding powers. And this touches in a way on a different criticism of international investment law and arbitration, which is that it's extremely expensive, right? And so I was wondering if you had any thoughts already on how this may be funded in a sensible way.
I think you're absolutely right. I think there is a real issue. Arbitration has become real expensive. You see awards and costs now running in the course of dozens of millions of US dollars. I'm not sure whether what I propose is an answer to that, and I take entirely the point. I need to think about it a little bit more. But it's a fair point. It's a fair point that we need also to address.
My name is Amelia Onyema, and I've been talking about engaging local communities and host communities in investment disputes. But I'm just wondering, I find your ideas, as usual, very, very fascinating and very intellectually challenging. But I'm asking myself, and I'd like your views on this, would it make much of a difference if this is a system constructed by states and we continue to, say, investors who, by the way, part of the definition of investment is that you need to take some risks, and we give them all of these protections, and there is no accountability. And so the point being, do you think that in addition to the suggestions you've made, that we do need to rethink the content of these treaties, what it is that states are committing themselves to?
Thank you, Emilia. I think we do actually currently rethink what the treaties say. There is a third wave of treaty negotiation and treaty entering, and that is much improved in the sense that you described. It allows for more space for regulation for states. There's been some noticeable move towards that. The problem, of course, is that these treaties are just entering right now. They need quite many years to catch up with disputes. We're still dealing with many disputes from treaties that have been signed in the 60s, 70s, and the 80s. So there is a system there. I think the question that we need to ask, and maybe is what you suggest, is whether we still need a system of adjudication, legal adjudication, or, because you said, they accept a risk. The answer to this whole debate would be, well, should let the investors take any political risk they want. There's been some views about that. I don't think that's the right view. I really think that we still need a system of adjudication that is independent. I don't think that political insurance should be the answer. I don't think that we need to treat justice as another form of insurance risk. It's way too precious to be treated like that. So I just don't agree if what you were getting at was, maybe the answer would be the risk to be addressed by way of political insurance. I wouldn't agree. I would think still we need a system of adjudication. The question is what? This is what we've been debating. How we can find an intelligent, principled way to deal with these matters. We should be able to find it.
Thank you for a very thoughtful lecture, Stavros. And I know that the solutions you proposed at the end are very broad brush at the moment. But when we look at this concept of public interest that you mentioned, I mean, presumably we're still going to be looking at balancing investors' rights against the interests of people in sovereign states. And isn't there a risk that if we're always going to have to be balancing those rights and we're going to have to come up with some principles, ultimately the new system is just going to become a proxy of the old system, and we're going to have to find a way to balance them with principles and rules, etc. So how is this idea of a public interest, apart from the fact that it's multidisciplinary, and perhaps there'll be more thoughtfulness given and to the rights of people, but ultimately, how is it going to end up looking different from the system that we currently have?
You're absolutely right, Sapna, and I take also the point that what I propose effectively is replacing a set of principles with another set of principles. That's inevitable. If I still believe in adjudication needs to be decided on the basis of principles. There are two issues here, two I think, responses to the very valid question that you posed. First, I think, as I mentioned, the principles currently that we have to deal these questions with, they're not appropriate, right? They're too, in a way, they're too broad that they had to be narrowed down to legal tests. These tests eventually emancipate the idea of public interest at all, right? There's no public interest left if you break down the idea of fair and equitable treatment. What I propose is, of course, to come up with different principles, but principles that hopefully will be appropriate to account for a protection of public interest without necessarily going down the rabbit of just legal tests. How this can happen, I really don't know, and I mentioned that it's just a broad brush theory right now. I have no answer to that, but I think I do have the answer to the second point I want to make, that even if we left the legal principles as they currently are, even if we just inserted some more interdisciplinary expertise from other fields, to make a more informed decision about what is it at stake when we decide these issues. If we had the views of economists, if we had the views of political scientists, if we had sociologists, I believe that we might have come to a better outcome in many of those cases. So forget the principles, but you're right, we need to replace them with another set of principles, even by inserting some more interdisciplinary inquiry into the decision-making process. I think this of itself would have a benefit.
Thank you for a fascinating, outstanding lecture. You seem to be describing something that is akin to an international public inquiry, perhaps. And I'm picking up on the point that was very validly made on the other side about the cost of that, but also the process of that. You still spoke about tribunals, but I'm wondering whether what you're really moving towards is some kind of standing inquiry body in which the two participants, the state and the investor, are merely two of the people who testify to that body, rather than having to assemble the cases to present to a tribunal.
I think you're absolutely right, Alistair. I think if you take what I propose to its logical conclusion, you will have to end up with a form of a standing inquiry like the ones that we're all familiar back in the UK. And I think you're absolutely right, and I take again the point about the process, the time, and the money that might be involved in these public inquiries. Now, if we agree on the principle, we don't necessarily have to have this kind of convoluted, time-consuming processes before these inquiries, standing committees that may have to decide. But if we think that this is a better way to address that, it might be worth considering adopting those. I'm not just saying that it's a magic bullet, a silver bullet, but I'm just saying we need to consider whether moving to a different paradigm of dispute resolution might be worth our time here. I don't know, but I understand what you say. Moving from ad hoc tribunals to standing committees, is this the question? I think it's worth considering at least.
Professor Brekoulakis, thank you very much. I understand that you are proposing that the law and its practice at the moment is not enough to look after the interests of the world that has developed into the state that it's now become, where nations feel that they have the right to withdraw from agreements or do things which the rest of the world may find not morally correct. And I think that this is such a brave project that you're embarking on, this thought that you're putting in our minds, that we have to admit that we have to live beyond the law, that we have to be pluralistic in our approaches to solutions to be effective. And I applaud you for that. And I think that the exploration of this subject will take a long time, will take a lot of brain power, and I wish you all the very best.
Thank you so much, Ms. Hwang. I think many of the tribunals that I've sat in would benefit from your expertise as a banker and of the understanding that you had of the system of international trade.
Good evening, Professor. Thank you for the wonderful lecture that you just gave. I understand that you focused on investment arbitration in your lecture primarily, but one other place where states are also a party of arbitration are international commercial arbitrations, because the current state is a contractual state. They routinely, in procurement contracts and other construction matters, they constantly engage with private parties, and then we treat the state as a commercial entity, which it isn't. It's a chaotic entity. It keeps saying things and then recalling them. And then we impose commercial liability on them. So is there a need to rethink the commercial arbitration aspect of states as well? Or that should continue and we should focus on investment arbitration right now?
You're absolutely right. I mean, I've argued elsewhere that there's also a blind spot in the intersect between public and private law. And you're absolutely right to describe that, is this area where you have these big concession contracts, these big public contracts that are effectively commercial contracts or are treated like that, but on the other hand, you have a public entity being one party of that, and the subjects, the main objective of these contracts is a big infrastructure project to benefit the public interest. So here you have what we treat as a commercial contract with an entity that seeks to serve the public interest, and we treat it in international arbitration entirely as a commercial commodity. This cannot be the case. This cannot be the case, because if you look into the main distinction between public and private law collapses there. There's this confluence of the public interest that you find in commercial contracts, in concession contracts. And indeed, we haven't done a very good job. Just to give you an example, in our case that I sat as an arbitrator, we had one concession contract in relation to the exploration of a big airport. In the contract, it was signed 30 years ago. There was one clause allocating the risk of a pandemic onto the state. Right? Now, at the time, the possibility that we had a pandemic seemed to be too vague, too unlikely to materialize. When the pandemic strikes then you have the investor bringing claims against the state, hundreds of millions of dollars, because they say, well, you've took the decision to close the airport, you owe us money. The pandemic is a risk that you took. The answer of the state, well, I did that to protect the public interest, was not something that the tribunal could take into account, because there isn't any idea of how to account for the public interest is this concession contract that is included into the law. The state, even if the state had lawfully taken decisions to protect the public interest and close the airports to save lives, that wasn't translated in any legal doctrine that we had to deal with. It certainly wasn't translated in the law or the contract itself. The contract itself explicitly was providing that this is a risk that the state will take. Now, you may ask yourself, is it fair? And you have some states to say, all right, you need to save lives. You need to do whatever you want to protect the public interest. But at the same time, you serve them with a bill of $100 million for doing that. So yes, you're right. This is not just investment treaty arbitrations. There's also one blind spot there in concession contracts and commercial contracts for public infrastructure projects, that you have one counterparty being the state or a state entity.
Thank you. Dimitri Katsikis here from ANO Sherman. It's my privilege to attend the lecture. It's also my privilege to thank you in your native tongue. Ευχαριστούμε πολύ. My question, you paint an ambitious picture of the future, and of course, the grander the ambition, the more the questions that we can quickly see. My question is not about the future. My question is about the transition to the future. How do we move from the system that we have currently to the system that you envision? And I, in the same way that Sapna caveated her question, I also caveat mine. I know you're speaking in broad brush terms. How do we do that? Do we all agree to abandon the old system? And if so, who is we?
Dimitri, thank you very much. I think that's a valid question as well. We're several steps far away from what I would describe as okay, we're implementing the system. We first need to develop another system of doing things. Part of, I think, of the inquiries, I've never thought the question of transition, I have to be honest. It's a valid question. Again, I take the point. Too many questions, as you said, too many less answers that I have to give. But I don't know the transition. We still need to understand how to develop another system of accounting the public interest more effectively. I think that's the immediate task, or at least that's one of the tasks, and see how we can insert some more interdisciplinary inquiry into the decision-making process. Now, what would be the transition to move from the current status quo to another system that we might think can deal with these things better? Again, I don't know, Dimitris, but again, that's a valid question. I'm afraid I can't give any answer to it.
Thank you.
I just have one thought, and my question is whether or not the cure you prescribe fits the disease that you've identified. You're asking for more experts, multidisciplinary experts, non-legal experts to be sure, but experts nonetheless. But the disdain that you talk about, that is about international arbitration, is in large part due to its democratic deficit. So if that's the problem, is not something like a more transparent and more publicly participative kind of dispute resolution procedure part of the answer?
Thank you, Mark. If you effectively say that if we insert more technocratic knowledge into the system, that might be perceived as less democratic, is that the question?
Well, not less democratic, but not much better than what we have now, right? We have, instead of technocratic lawyers, we have technocratic scientists or political scientists or whatnot.
Yeah. I think you're right. There is a perception that international arbitration was unable to defend itself because it didn't respond to the question of, how these legal technocrats can decide this issue. So what you effectively say that instead of having legal technocrats, we might have economics. And in some countries, including Greece, this didn't go very well if we had the economists taking over questions of public policy. I understand what you say. That's why I think that we need to broaden the inquiry and take more sociologists and other disciplines that actually can account for what is the social public policy, the protection of it. But there is a perception that these complex issues will be decided by reference to some form of technocratic knowledge that only few have in their hands. I understand what you say. I think there is an element of perception there. We do have, as I say, this problem in international arbitration. We are seen as being too narrow legal technocrats. I understand. I understand the point.
Donna Ross, thank you so much, Stavros. I do believe that some type of adjudicatory or whether it's a separate body from arbitration is necessary. I think one of the problems is trying to separate, I guess, the wheat from the chaff in the cases where it's true public interest, and what the system has been there to protect was that states pretending it's public interest when investors' rights are being breached. But I was just wondering, and I guess my role at U.S. law is to teach international mediation, so I feel compelled to throw that into the mix here, not as a solution or a replacement, but when we talk about the different social groups, communities involved that cannot be taken into account by an arbitral tribunal, and with the new exit mediation rules, do you see a role for mediation or some kind of a more negotiated procedure in addition to whatever ultimately replaces or enhances international investment arbitration?
This is an excellent question. Thank you. I think you're absolutely right. I mean, the process of mediation, for some reason, never took up. It never took off. It wasn't accepted, especially in the field of international investment, as originally we thought it might have an impact. It just hasn't had the impact that we thought it would. Now, what are the questions? Why this is the issue? I just don't know. But the way that you actually describe the mediation process of more inclusive, of more social groups, of this discursive itinerary process that can actually lead us through sensible discussion rather than adjudication of strict legal rules to something that is more is fairer, is more widely accepted. Only this process of mediation that people buy in, that parties buy in, that wider communities buy in can offer. There's no way that international arbitration as a system of adjudication can replace this sense of closure, a sense of collective participation that in mediation that you describe. You're absolutely right. I just don't know why mediation hasn't, succeeded in that. I just don't know, but it makes very good sense.
Right. Hello, my name is Alicia. I'm from Nanyang Poly. So I hope my question is more simple. So I just wanted to ask why sovereign immunity was really a thing, because it seems like it can very easily override international law. And I wanted to know what you would do. What would you propose to overcome this?
Thank you very much. I think one of the principles that the propositions rather that I set out was that we need to keep sovereignty in a form of accountability. It's a very important principle of the rule of law. We cannot move from that. We cannot allow politics to take over entirely that international law. Now, sovereignty, I understand that there is some value in it. There's some cases that you need to have the final decision maker, which is what is, the sovereign entity. At some point, a decision has to be taken. This decision must be taken by a sovereignty. I accept that. But this decision, by no means, can be unaccountable. We need to make sure that these decisions that the sovereign entity takes as the final decision maker in the way that we have politically organized ourselves is sovereignty. I don't dispute that for a moment. But I think that even if the way we organized ourselves, we put sovereignty at the very end, the decision of the sovereignty cannot be unaccountable. There must be some broad standards, some principles to have this sovereignty's decision be reviewed and being accountable for.
You asked for my indulgence? Okay, Lawrence, please.
Thank you.
Very briefly. Thank you, Lawrence.
Yeah. I thank Stavros for making the suggestion that the pool or expertise that you bring about adjudicating investor state should be expanded. I totally agree with you. But I do want to be a contrarian in terms of your original observation that states or political factors are now coming into play. My question is why? Why? I now observe that the investor state system of arbitration is actually a Western construct. So developing states and the developed states, in the early days, when entered into contract, into the BITs, the developing states want the investments, so they were asked to give protection. So actually, what is happening now is that you find that some of the developing states, European states, for example, Western countries, are exposed to claims, and therefore they want to change the rules. So this is my different observation. And I thought that, why should that be the case? Should the same rule continue to play until the end of the game, instead of stopping and have a change of rules? So that's my observation. I suggest that your observation or your suggestion that the way of adjudication, instead of moving away from tribunals, but to change expertise in the tribunals, de-lawyering may be one thing that we can do a little bit more, and so that the adjudicative process in investor-state arbitration will morph into something better than what it is now. So that's my little observation I have on your.
Thank you. If I may very briefly comment on the first observation, Lawrence, that you made, you're absolutely right. I mentioned previously that the three reasons that I think were changed: the scale of international law, the judicial activism, and the attitude. But there's a fourth one which I didn't have time to address. You're absolutely right. Another thing that changed and shifted the context of the discussion was that, as you rightly said, originally the developed states thought that this is a system to protect their own investors. Now, down the line, 40, 50, 60 years ago, they found themselves on the receiving end of these investor claims. And then the thinking started to change. Then you had European states that were the recipients of a number of different claims, saying, hang on a minute, we developed the system not to have to face claims ourselves, but to protect our investors. And you're right to observe that this realization brought about the need to shift the policy on investment arbitration. So not only I'm not going to dispute with that, I think I wholeheartedly agree with your observation. So this was a critical, I think, moment where many states of the developed world realized that this system, can come back and bite us.
This ends the question and answer period. May I ask you to thank our speaker in the usual way. We will now have the last segment of our lecture today, the presentation of tokens of appreciation to Dr. and Mrs. Hwang. May I ask Andrew, the Dean, to come to the front, as well as Mrs. and Dr. Hwang. The special gift we're going to give are 4 porcelain plates, each one featuring a different iconic building of NUS. The first of these plates is actually none other than our historic Bukit Timah campus, which very soon for us will become even more historic. In our mark of appreciation. Thank you very much and good evening.